Negotiable Instrument Act 1881. What is a check? Types of check. Section 138 of Negotiable Instrument Act. What ingredients are necessary? Procedure to be followed for filing of cheque bounge case. Do subscribe the channel Drive on Law and click bell icon to get notifications by Drive on Law. What is a check? Types of checks. Checks is very common form of negotiable instrument. If you have a savings bank account or current account in a bank, you can issue a check in your own name or in favor of others, thereby directing the bank to pay the specified amount to the person named in the check. A check is a document which guarantees the payment of a specific amount of money on demand to a certain person or to the bearer of instrument. You can use this printed form to make payment from your bank account. When you write a check, you enter the amount of money and whom to be paid to sign and hand it over to the person you want to make payment to. Your bank then pays the money to that person. That person is called as a payee from your account. A check is a document which orders a bank to pay a particular amount of money from a person's account to another individual or company's account in whose name the check has been made or issued. The check is utilized to make safe, secure, and convenient payments. It serves as a secure option since hard cash is not involved during the transfer process. Hence, the fear of loss or theft is minimized. The person who issues check is known as drawer. The person who received check is called as payee. The bank of the person, that is drawer, who has account is called as a drawee or drawee bank. Here, check means if any person have the account in the bank, then the bank people issues the checkbook to the said person. If the said person wanted to means give the money for anyone, then he can issue the check and specifically write the amount what he intend to give to the other person and put the signature and submit his check. Then the said person goes and takes the amount from the said bank by giving the check to the said bank, and after clarification the said bank provides the amount to the said person. So here the person who issued the check is called as a drawer, and to whom the check is issued, that person is called as a payee, and drawee is the person, that is nothing but the bank. So the bank is the drawee here. The bank will provide the money which was there in the account of the drawer to the payee. There are different types of checks available within financial institution which serves different purposes. Broadly speaking, checks are different types. Some of them are bearer check or uncrossed or open check. When the words or bearer printed on the check is not cancelled, the check is called as a bearer check. A bearer check is made payable to the bearer, that is, it is payable to the person who presents it to the bank for encashment. However, such checks are risky. This is because if such checks are lost, the finder of the check can collect a payment from the bank. Bearer checks can be transferred by mere delivery. They need not endorsement. In simple words, a check which is payable to any person who presents it for payment at the bank counter is called bearer check. When a check is not crossed, it is known as an open check or uncrossed check. These checks may be cashed at any bank, and the payment of these checks can be obtained at the counter of the bank or transferred to the bank account of the bearer. An open check may be a bearer check or a order one. Here, bearer check means the person who holds the check, that person, even that check was issued to that person or not, it is not the matter. If the person holds the check without his name, and there is there on the above of the check it is not mentioned as a account payee check, then the person who holds the check can go to the bank, and across the across the cash counter he can issue the check, the said bearer check, and he can obtain the amount, because on the said check it was not mentioned, or it was not cancelled the bearer which was printed on the above of the check. Then that can be encashed by any of the person, even the to whom the check was issued, or if not, it was found with the third person who is not at all liable for that check. Even that person also can take the encash the check amount from the bank. Here is one example for easy understanding for you. A gives a check to B for an amount of 1 lakh. While giving the check, A not strike out the bearer word mentioned on check, nor he cross the check by two parallel lines on the corner of the check. Here B can encash the amount of rupees 1 lakh from the bank because B is the holder of the check. So here B has the check along with him, and that is a bearer check, so he can go to the bank and he can encash the amount. Even if B gives to the third person C also, even C can encash the amount, because here the name is not mentioned and it was not crossed by the presenter. Crossed check. Crossing of checks means drawing two parallel lines on the left corner of the check with or without additional words like account payee only or not negotiable. A crossed check cannot be encashed at the cash counter of the bank, but it can only be credited to the payee's account. This is safer way of transferring money than an uncrossed or open checks. Example, A gives check to B for an amount of 1 lakh. While giving the check, A mentions as account payee, or he crossed the check by two parallel lines on corner of the check. Here, B can encash the amount of rupee 1 lakh from the bank only through his account, that is, B has to deposit the check in his account. Then after that, drawn check amount deposit in B's account from the A's account. So here the transaction will be done through the accounts, so it will be safe and also will be recorded. Means in the both accounts, the drawer and also the payee's account, it will be recorded that the drawer has issued the check and the check was withdrawn by the payee on which date and when the amount was deducted from the drawer to the payee's account. So it will be a record. So it is very safe for issuing of the crossed checks. An antedated check. Check in which the drawer mentions the date earlier than the date on which it is presented to the bank. It is called as antedated check. Such a check is valid up to 3 months from the date of the check. For example, A issued a check on 10th January 2010 to B, but date on check bears a date 20th December 2009. Means he issued the check in the month of January 10th, and but the date was mentioned that prior to that, that is 1 month before, that is 20th December 2009. Whatever the date is, but from the return date, the validity of the check for institution of the check in the bank will be only 3 months. So within the 3 months from the date, the said person has to encash the amount. Post-dated checks. Checks on which drawer mentions a date which is yet to come, that is future date, to the date on which it is presented is called post-dated check. For example, if A issues a check to B on 10th January 2010, bears a date of 25th January 2010, it is a post-dated check. Means here A issues the checks to the B on 10th January only, but the date is mentioned on the said check, that is 25th Jan 2010. So the bank will make the payment only on or after 25th Jan 2010 to B, and B has to submit the check also on 25th January or after the 26th January within the 3 months period. So this we call as a post dated check. A check is a widely used method of payment, and post-dated checks are frequently used in various transactions in business life. Post-dated checks are given to provide a certain accommodation to the drawer of the check. Therefore, it becomes necessary to ensure that the drawer of the does not abuse the accommodation given to him. So why this post dated check is very useful and existing in the present scenario means they mentions the date, post date, and they issues the check, and the drawer says to the payee that to deposit after the date which was mentioned, because the convenient time for the money depositing in the said bank is that period, so they issues that checks. So whatever the check's validity is only 3 months, and from the date written on the check and the presentation to be within the 3 months, then only the check is valid. If not, the validity of the check will lost. The ingredients required for complying with Section 138 of Negotiable Instrument Act are: a person must have drawn a check for payment of money to another for the discharge of any legally enforceable debt or other liability. The check has been presented to the bank within a period of 3 months. The check is returned by the bank unpaid, either because of insufficient of funds or that it exceeds the amount arranged to be paid from that account by an agreement made with the bank. Means the check would be returned by two reasons, that is insufficient funds, means sufficient funds are not there, which was quoted, the number means the figure of the amount which was quoted on the check is check does not have the funds in the bank of the drawer, one reason. And if the drawer made an agreement with the bank people that only for the specific amount the check should be drawn in the said bank, then if the amount mentioned on the check exceeds to the agreement which was made by the bank people, for that also check will be returned. The payee makes a demand for the payment of the money by giving a notice in writing to the drawer within 30 days of the receipt of information by him from the bank regarding the return of the check as unpaid. Means when the check is returned, the bank people issues the check return memo. So after receiving the check return memo by payee, the payee has to send the legal notice to the drawer within 30 days. After receiving the check return memo, within the 30 days, he has to issue the legal notice that we call as a mandatory notice also to the drawer, that as you issued the check for the legally enforceable debt, so but the check, when I presented the said check in the said bank, it was returned, and the particulars has to be mentioned in the legal notice, and he has to furnish the legal notice to the drawer. The drawer, after receiving the legal notice through the registered post, if the drawer fails to make payment to the payee within 15 days of the receipt of the notice, means here the drawer gets the grace period of 15 days. So in the grace period of 15 days after receiving the notice, if he thinks that the mistake was done by him, or if not other reasons, then if he plan to pay for the amount of the debt amount within 15 days, there is no question of criminal action against him. But if he fails for payment of amount, then legal action will be initiated against him. Example: A took hand loan from B for an amount of 2 lakhs and promised to pay within a year, and issued a check of rupees 2 lakhs in favor of B with post dated on the check. A year passed, but A not paid the amount as promised. Then B presented a check for payment of amount in the bank. Then the check was returned on the ground of insufficient funds in the account, and bank issued check return memo. Then B issued a legal notice to A within 30 days of receiving check return memo. Further legal notice received by the A, but he failed to pay the debt amount. Then the payee, what he do means he go with the further initiation. Procedure to be followed for filing of criminal case under section 138 of N.I Act. A legal notice is to be issued to the drawer within 15 days of dishonor of check by registered post with all relevant facts. The drawer is given a time of 15 days to make the payment. If the payment is made, then the matter is served and the issue is settled. On the other hand, if the payment is not made, then the complainant, means here the payee is the complainant, is to file a criminal case process under section 138 of N.I Act against the drawer. So drawer is here accused within 30 days from the date of expiry of 15 days specified in the notice within the concerned magistrate which has the jurisdiction. So after the grace period of 15 days, the payee gets the period of 30 days to filing the case against the drawer in the court where the court has a jurisdiction. Example for you. B received check return memo from bank on 2/2/2021. So here B get a period of 30 days to issue legal notice. Means after receiving the check return memo, the payee gets the time of 30 days to issue the legal notice. In between also he can issue the legal notice, that is his choice, but maximum period is the 30 days. So that is 1/3/2021 he got the 30 days period. For a point of time, we take that B issued a legal notice through registered post to A on 10/3/2012 only, means 20 days before only he issued the legal notice. A received the said notice on 17/3/2021. Here A gets the grace period of 15 days from 17/3/2021. So after receiving the notice from the by the A, he gets the 15 days period. So from 17/3 to 3/21 to he gets the 15 period, that is 31/3/2021. If A pays the debt amount to B, then the problem will be resolved. There is no question of going for the criminal action. So, however, if A not paid the debt amount, if he is not paid the debt amount within the 15 days to B, then within 30 days, means from 30/3/2021, B gets the 1 month time for filing of the case. So B can initiate the proceedings, criminal proceedings against the A in the court of law as through the private complaint. He has to file through the private complaint. The complaint should appear and provide relevant details for filing of the case. Means the complainant has to appear before the court and he has to file the case through the relevant documents. That is, if it is a legally enforceable debt, if the drawer issued any promissory note or if not anything, only basing on the check only the transaction was done. So what is the proof is there? Everything he has to furnish by through the relevant documents, and he has to file the private complaint. If the court is satisfied, then court takes the cognizance of the case under section 138 N.I Act and summons will be issued to the accused. If accused abstains himself from appearing, then the court may issue a bailable or non-bailable warrant. On appearance of accused, he may furnish a bail bond. In case he pleads guilty, the court will order punishment. If denies the charges, the complainant may present his evidence. The complainant will be cross-examined by the accused. The accused will be given an opportunity to lead his evidence. Accused and his witnesses will be cross-examined by the complainant. The last proceedings is arguments, after which the court will pass a judgment. If the accused is acquitted, then the complainant can go to the further appeal in the High Court. If the accused is convicted, the accused person can file an appeal in the Sessions Court. So if there is acquittal, then the complainant has to approach the High Court by filing the appeal. But when the conviction was passed by the court, means accused got convicted, then he can file the appeal in Sessions Court only. So that is the main difference between the acquittal and conviction. Thank you. Please do subscribe the channel Drive on Law and click the bell icon to get notification by Drive on Law. In next class, we go with the judgments, landmark judgments, which are mandatory to proceed with the case of enacts, and what are the presumptions provided for the complainant, and how the presumptions can be break by the accused. These all the details will be furnished in the further classes of enact. This is only the first video. This is the basic information, and we have a number of landmark cases. With the said landmark cases only, the cases deals in the court, so that is very much needed for the advocates and also for the legal luminaries to proceed with the cases.